Good morning, everyone, and welcome to today's Head Teacher Chat Masterclass. I'm Jonathan. I'll be hosting the session today with dealing with complaints and challenges they present. And whether you're primary or secondary or trust-wide role, we are pleased to have you here. So handling complaints is probably one of the most demanding things in our school leadership at the moment. There's so many more complaints that are happening. In our community, we probably have 2 or 3 messages daily about complaints and how to handle them. So I'm really delighted to have Paul here to talk through all the strategies and all the help that can be done on dealing with these complaints and actually really support you as a school leader. So, morning, Paul.
Hello. Good morning, everyone.
So, the aim of the session is to equip you with clear, practical tools to support your school leadership. So I'm going to hand over to Paul now, and he's going to give you the whole session about handling complaints. If you have any questions or any thoughts, please put them in the chat, and we do our best to answer them as we go along. So it's over to you, Paul.
Thanks very much. We do have some presentation slides that I hope you can see any second now. I can see them. So good morning, everybody. So I'm Paul Davies. I'm the complaints manager from HFL Education. And today's session is on handling complaints in challenging times. Essentially, we will look at dealing with complaints and the challenges that they present. So in terms of what can come with them. So something we're seeing a lot of frequently reported, both in the headlines, which we'll shortly come to, as well as what's reported to us as HFL Education through the products that we offer, is unreasonable behaviour seems to be accompanying a lot of the complaints that schools are dealing with. So the focus of today's session, very much it's split into 3 parts. So the first section will be to look at the current landscape. So we'll look at complaints in the news, how they've made headlines, the fundamental requirements of the process. So what is needed to ensure compliance. We'll look at stages of the process. So how many stages should you have and who is involved in each one? What can and cannot be accepted as a formal complaint, because this is something that we get frequently asked about. We'll then move on in the second section to look at dealing with complaints themselves and unreasonable behaviour that can come with them. So to that end, we will look at what is reasonable in practical terms, but also what is unreasonable. So what is the legal definition in education legislation of unreasonable? And what does it actually look like on an everyday level? We will then move on to look at decision making and particularly the importance of arriving at sound decisions through due process. We'll look at reaching findings that are clear so that a line can be drawn. We will look at outcomes and remedies in terms of what's deliverable and what isn't. We will also look at making recommendations to try and ensure that they're realistic and that they're likely to have an impact. And then we will move on to look at the position for staff being complained about in terms of their rights. What's the position also for staff when they're called instead as a witness? And what does that process entail? How does it work? We'll look at what staff can expect at a formal hearing, which is particularly important if it's the first ever complaints process that a member of staff has ever been involved in. And then we will look at what can happen beyond the school's complaints process. So where could the complaint potentially end up? And then the final section, we will give you some key hints and tips to take away. So I'll provide you with some key links, some useful reminders. We'll look at a couple of frequently asked questions that come up each academic year, as well as being happy to take any of your own. And then I'll quickly show you the complaint support that can be available from HFL. So in terms of complaints being in the news, I've just put you a few headlines on this slide here that I'll leave you to read at your own convenience. Obviously, they're from a variety of sources across both printed media and digital, all of which are showing sort of over the last year, 18 months, that complaints are both rising in number and also in their complexity, with people seeking to add to the complaints they've already made or change them partway through a process, or the complaint itself that's originally submitted is made up of a number of constituent parts, each of which are time consuming and challenging to investigate and respond to. We're definitely seeing that social media is making things more difficult in the complaints arena. It's quicker and easier than ever before for somebody to make an allegation, or at least to say something negative about a school or somebody working within a school, put this out to a wide audience, or at least a potentially very wide audience, very quickly, and before you know it, the school could be on the receiving end of some really negative publicity, when actually at the root of it is something that could be partly or wholly untrue. So it's very difficult. This can be very damaging, both for individuals working in schools in terms of their professionalism on occasion being called into question. It can impact therefore on their well-being and mental health, as well as the situation being reputationally damaging for the school, the trust, or the federation, depending on the type of school that you are. So in terms of some fundamental requirements of the process, your complaints process must be published online, either on the school's website or with a link to the trust or federation website if you're part of one. It must have clear timelines and escalation points for each stage. And remember that the DFE fully expects escalation requests to be agreed to. This is why it's incredibly important to ascertain in the first place whether the complaint qualifies for acceptance as a formal complaint or not. It's important to define the stages and who is involved at each one. We recommend that you state the role or the job title of the person rather than names of individuals, so that if and when those individuals leave the school or move on to a different role within the school, you don't have to keep updating the complaints policy. You should have clear guidelines around the process, particularly if the circumstances are unusual or complex. So, for example, state if the complaint is about, for example, the head teacher or yourself, or your chair of governors, for example, what happens that's slightly different in terms of how it would have ordinarily been dealt with. You also should include guidance on vexatious complaints and unreasonable behaviour. We are seeing increasing instances of this. It's very much on the rise. It's important to have guidance in place and for you to know that it's there and for your staff to know that it's there. If somebody simply will not stop, they will not accept the outcome, you need to know how you can take perfectly permissible steps to try and draw a line under this and afford some protection for yourself, staff and governors. It's important always to look at the procedure and to ask the question, is it fair for all? So, for example, is it made sufficiently clear that the policy can be made available in different formats, and that reasonable adjustments will be considered and facilitated as part of that complaints process? And last but not least, has it been personalised to your setting? So does it contain the school's contact details, the school logo, the school motto, if you have one, etc.? This is something we highlight the importance of, particularly where schools perhaps may still be maintained and therefore have adopted guidance from a local authority. Often we do come across a number of cases each year where the adopted policy and procedure from the local authority has simply been cut and pasted, and it needs to be personalised to the setting. In terms of suggested stages of the process, this is the most ideal suggested model. It's to have a first informal stage, otherwise some schools refer to it as stage one, that provides an opportunity to resolve the issue through informal liaison with the class teacher. At this stage, the issue tends to be referred to as a concern rather than a complaint. The first formal stage, otherwise referred to as stage two in certain schools' procedures, involves a complaint in writing to the head teacher or principal. That then kicks off an investigation that can be carried out by the head teacher, but always remember that you do have the option. It's permissible to delegate the task of the investigation to somebody else, and that person then provides you with the outcome of their investigation for you to agree the final findings and send an outcome letter. The second formal stage, otherwise referred to by some schools as stage 3, is a complaint heard by a panel of impartial governors in a formal setting. 3 is the recommended number of governors that we have always prescribed at HFL Education, with one person serving as the chair of the panel. However, some schools and trusts do use more than this. So we also support schools that sometimes have panels made of 4 governors and 5. Remember, for academies and free schools, at least one panel member must be wholly independent of the management of the setting to which the complaint relates as well. Thereafter, there is a final stage, sometimes referred to as stage 4, whereby the parent or carer or whoever the complainant is can approach the Department for Education, and the DFE's School Complaints Compliance Unit may or may not decide to undertake further inquiries into that complaint. If the complaint is against you as the head teacher or principal, complaints should be addressed to the chair of governors instead, and any request for escalation should then be made in writing to the vice chair, unless, of course, your policy individually states differently. So in terms of what can be accepted as a form of complaint, it's really important to look at both what can be accepted and what cannot be accepted, as there are some misconceptions around this. And as I've already mentioned, it's really imperative that we only accept formal complaints where they qualify for acceptance as such. Because once we accept something, the DFE fully expects a school to allow that complainant to escalate through all further stages of the process that exists. So if we've accepted something that perhaps we shouldn't, where we cannot deliver the outcomes the person is seeking, it becomes a very difficult situation where we're committed to still progressing that complaint when we know we cannot deliver what the person wants. And ideally, the outcome of any process of complaint is that you at least try to satisfy the complainant in some way. We don't want somebody even more dissatisfied at the end of that process than they were at the beginning. So the vast majority of issues will come from parents or carers of children who attend the school. We see a lot of issues, pastoral issues raised, particularly around bullying. We tend to see 3 main types of bullying allegation. We see allegations of child-on-child bullying, allegations from parents that they believe a member of staff is picking on and bullying their child. And to an extent, from time to time, we see allegations from parents where they state that they themselves consider that they are being bullied by a member of staff. That's usually in relation to a situation where a member of staff admittedly has had to deliver an unwelcome message to a parent on one or more occasions. We also can, through this process, see complaints about members of staff that qualify for acceptance, such as the example given here, their conduct in a meeting. But always remember that such complaints may then lead to further involvement of HR services where that's necessary. So if the complaint is upheld fully or partly. Complaints from parents of former pupils, where the child's name has been removed from the school roll within the previous 3 months. Remember with these types of complaint that there is a discretionary element attached to this. So the DFE states that 3 months is generally considered to be an acceptable time frame in which to expect a complaint to be made. The presumption should be on accepting complaints unless you identify that there are good reasons not to. So if somebody comes forward where they're making a complaint about an event or incident or series of them where they occurred more than 3 months ago, the school can legitimately respond to the person and go back and ask that person to confirm why they didn't raise these issues sooner, and certainly within the 3 months. If the person comes back with reasons that you do not consider are sufficiently compelling or exceptional to accept the complaint as a late complaint, then you are able to conclude rather that you do not have to accept that complaint and you will not be doing so. But you need to be able to demonstrate nevertheless that you went through the process of giving it that consideration. We can also see complaints raised about incidents that have occurred during the school day or on other school related activities that may have occurred off-site, such as a school trip, where the school is still responsible for the pupils. And then from time to time, we are likely to see issues raised from members of the public that the school is directly responsible for. But you must remember here, it's not the case that anybody can complain about anything to any school at any time. The issues that the person is seeking to complain about on each occasion must revolve around the school's provision of facilities or services. If the issues don't revolve around that, then the school does not have to accept the matter as a formal complaint. In terms of what cannot be accepted as a formal complaint, there are a number of scenarios where the formal complaints process would not apply. And so we've put the key ones here for you. So a member of staff attempting to complain about another member of staff, for example, about their behaviour or professionalism, that would be potentially where the staff grievance procedure would need to be used instead. A member of staff stating that they are dissatisfied with an action or a decision of the full governing board, it would already have been given the full governing board's consideration, and so it would essentially amount to governors then being asked to mark their own homework again. Child protection referrals, so the complaints process cannot be used either to complain about a child protection referral being made or to try and prevent such referrals from being made in the first place. Appeals about admissions or challenging exclusions, either fixed term suspensions or permanent, any matters like this for which there is a formal right of appeal through an independent review process do not have to be considered as a formal complaint because that separate statutory process applies. With suspensions, whilst there isn't an independent right of appeal, the guidance on behaviour and exclusions from the DfE clearly states how suspensions should be considered. Instead, depending on the number of days in a term that the days of exclusion adds up to. So you do not have to consider those as a formal complaint either. We also get lots of inquiries about matters that are often referred to as internal management decisions. So matters such as class or teacher allocations do not have to be accepted and put through the formal complaints process, as ultimately the school is able to come to decisions through the head and the SLT in terms of logistics and class and teacher arrangements to enable the school to function and to fulfil its statutory obligations. Group or ringleader complaints, there are specific DfE guidance on this. So we cannot necessarily take, say, an open letter or an email from one person where they claim to represent, for example, 10 or 12 others. We would need express consent from each of those persons named within that email. So what the DfE guidance suggests on this is that where you have multiple people raising the same complaint, or one person claiming that all of these people signed below support this complaint, it's important to issue a response, but you could issue a response, for example, through the school's website and provide that copy of that response to everybody. In addition to this, matters that have occurred significantly outside of school session times do not automatically have to be considered as a formal complaint. So key examples here, matters that may have occurred over a weekend or a school holiday period, i.e. when the pupils are firmly the responsibility of their parent, carer or special guardian. And then last but not least, something we've already touched on the previous slide, matters that have occurred more than 3 months ago. They do not have to automatically be considered, but do remember that discretionary element. Feel free to go back to the person and point out that there is a 3-month time limit that generally applies. Therefore, ask the person to explain why they didn't submit the complaint sooner, and certainly within that 3-month time frame. So that concludes the first section. So we'll now move on to actually dealing with complaints themselves and the behaviour that can sometimes accompany them. So we'll also look as part of this at what is reasonable to expect and what is unreasonable in terms of requests that people may make. But just before we do move on, does anybody have any questions that they wanted to pop in the comments bar? Okay.
Really good so far, Paul. There's no questions at this moment. There's quite a few people watching, but carry on. Really
Okay.
informative.
We'll carry on. Thank you. So, in terms of what is reasonable, reasonable actions would be listening to somebody, particularly if the meeting is taking place in person, the importance of demonstrating active listening through your body language and your responses, showing them that you are affording them your time, that you're taking time out of a busy schedule to listen to the concerns that they have and how they've, at least the person, how they perceives that they've arisen. Trying to see that person's point of view in order to understand their anger or perhaps their frustration or upset, acknowledging, of course, that complaints processes can often be really emotive. Some of the most sort of challenging and emotive ones I've ever been involved in supporting have been where perhaps a child has sustained an injury, either whilst at school or on a school-related activity. That's understandably really emotional time for the parent, the worry of initially finding out about that. Are they injured? How badly so? Often then followed by, well, the anger of, well, how did you allow this to happen? Is often the next response. So that it can be very challenging and emotive. It's about explaining clearly how a decision was taken. That's always important in terms of the decisions that we reach, that we'll come to shortly, about setting out the rationale for how we reach that decision and responding to the person to set out the school's position whilst demonstrating that you've balanced this alongside having regard for that person's views. Now, we cannot always agree with somebody. And so it's important to always set out how we've considered all angles before we came to the outcome and the decision that we did. It's also reasonable to apologise to somebody where we feel that would be appropriate and necessary. And remember that there are different ways of apologising depending on whether there is fault in the situation that's being complained about. So there is the kind of apology that is full, unreserved and sincere in terms of a situation where there has been a clear oversight or fault that's led to somebody experiencing a loss of opportunity or perhaps an injustice. Whereas there is the other type of apology where there isn't really any fault arising, but the person clearly feels aggrieved. So the apology there is more along the lines of, we're sorry to hear that you feel as you do. It's important as well to demonstrate reasonableness by acknowledging on occasions that something could have been handled either in a better way, or if not better, just perhaps differently. It goes a long way with most reasonable people in taking the heat out of a situation. It's also reasonable to try and offer a remedy if, of course, the situation can be remedied. It's not always possible to put somebody back in the position that they would have been had the issue or oversight not have occurred, particularly, for example, if the person has subsequently removed their child from the school, and then that you're still dealing with this complaint by that point. It's about explaining what will be done to prevent this matter from happening again. So trying to show that you will not repeat past mistakes or oversights. Demonstrating as well that you've used the complaint as a feedback tool for positive action. That's really important because that can help to show somebody and hopefully make them go away from the process feeling that it was at least worthwhile for them to take the time and go to the effort of making the complaint. In terms of what's unreasonable, it's important first to look at, well, what is the actual definition according to education legislation? So the definition of what's unreasonable is actually set out here in section 496 of the 1996 Education Act. So I have included on this slide the exact wording verbatim of the act there, that I'll leave you to read it at your own convenience. But what that essentially does is it gives the Secretary of State the power to prevent either a local authority or a governing board of a maintained type of school from acting unreasonably regarding any duty or power that they have. And to that end, under Section 496, the Secretary of State can on occasion intervene by giving a direction that they think is appropriate and necessary. For example, given here, perhaps to run a fresh panel if the panel perhaps didn't quite follow procedure correctly, or it may have been improperly constituted because somebody on the panel, it was demonstrated, already knew too much about the complaint to be considered impartial. The test to be applied here when considering whether an action is unreasonable or not, you may or may not have heard of this, is referred to as the Wednesbury test of reasonableness. Now, a decision is deemed to be Wednesbury unreasonable, or in other words, irrational, if that decision is so unreasonable that no other reasonable body, whether that be a governing board or a local authority, if they were acting reasonably, could have made that same decision. So as I hope you can see from that, it's quite a high threshold. So consequently, the number of complaints that go on to be investigated further on this basis each year is extremely small. The DfE receives far more approaches from parents and carers and special guardians in relation to school-based complaints versus the number that it actually undertakes inquiries into and investigates further. But it's always important to bear that in mind, because what a parent might tell you in their view is unreasonable doesn't necessarily translate into education legislation, and particularly this definition as being unreasonable at the same time. So in terms of what unreasonableness can look like on the ground, so it can look like this. So threats and intimidation being made and giving into them. So something I've seen a lot of from my years being involved in complaints, comments along the lines of, if you don't agree to this, I'll go to Ofsted. Sometimes with a person even giving their own date and time deadline for this. Deviating from what you would ordinarily do just because somebody keeps coming back. If you are confident and clear about your position, maintain that position, reiterate the reasons why, because actually deviating from it can cause more problems in the long run than you were attempting to solve. Setting aside the relevant timescale simply because somebody is difficult or they keep putting pressure on you to speed things up or potentially cut some corners. The timescales are there ultimately for a reason. So by all means, use them to your advantage. Responding again and again to the same substantive issues when there's little or nothing or else to say, often because the complainant appears to want to have the last word. Depending on the circumstances, if it makes no difference to leave it there and let them have the last word, then do so. Because sometimes the more we keep going back to somebody, it fuels the fire, as it were, and they keep coming back anyway. If, on the other hand, it wouldn't be appropriate to leave them to have the last word. For example, I was once supporting a school where the parent put in an email to the head, if I don't hear back from you, I will take it that you agree with my view that safeguarding is not important at your school. Obviously, we would definitely not recommend leaving something on that note. But as I say, if it makes no difference to let this person at least feel that they've had the last word on some occasions, then do let them. Finally, it's using other procedures or processes for no apparent purpose other than to cause the school disruption or to cause staff distress and anxiety. Key examples given here. So parents or carers appearing to exploit freedom of information or subject access request routes. These routes can legitimately be used for requested information, and they are frequently. But there are some occasions each year where these two pieces of legislation, the acts, are exploited by people who are requesting information either for the sake of it or they're doing it to simply try and the school feels, at least, that they report to us, that it's trying to wear the school and the staff down. Remember that it's not a foregone conclusion that you have to agree to every single request, and some requests can be refused on the grounds that they are considered to be manifestly unfounded or manifestly excessive. And there is clear guidance on this from the Information Commissioner's Office, and the ICO has a helpline that you can also consult for advice before you communicate your decision. So in terms of moving on to decision making, when doing this, it's essential to think about the following things. So what questions does the evidence that we've received, what the evidence that's been submitted, what does it answer? For example, in the complainant's email or their letter of complaint, or within their complaint form, or it could be information contained in a panel pack. Does the evidence that's been submitted, does it raise new questions? If so, what are those questions? If the complaint is about a disputed event or incident, what do we already know about it, but what do we need to establish by way of fact finding? Who do we need to speak to gain views on this? For example, are there current members of staff that we need to speak to, or is it a situation where the complaint cites members of staff who have since left or retired, or is it a case where it involves other parents and sometimes pupils who are potentially named as witnesses? In terms of what happened, was what happened in accordance with the published policy and procedure? If so, it's really important that we demonstrate in our response to the complaint that it was in accordance with our policy and that we had regard for this policy in our decision making. And last but not least, if not, what should have happened instead? And therefore we can demonstrate when we apologise for this, how we also propose to remedy this to prevent it from happening again. In terms of reaching findings, those findings need to be clear. So to this end, they either need to be upheld to demonstrate that we have found fault or oversight fully, partially upheld where we may have found some fault or oversight but not total. We haven't upheld the complaint because the evidence that was submitted did not support the claims that were made, or on some occasions we may have to conclude that we're reaching a finding of no judgment. For example, in relation to a disputed event or incident where there may have been no witnesses, or at least none that could be identified. All findings need to have clear reasoning behind them, and this is really important, particularly if the decision is going to be that you're not upholding the complaint, as the person is highly likely to be dissatisfied with this. They're likely to want to challenge further by seeking escalation. So we need to be clear, particularly on the wording we use for this. So we strongly advise that you don't simply say, I do not uphold your complaint. You be clear that taking into account all of the evidence that I've listed above, I am unable to uphold your complaint for the following reasons. In terms of outcomes and remedies, this is something we get asked a lot about. So we have a complaints toolkit that schools can subscribe to. It's a series of self-service tools that I will come to at the end of the session, but it also includes a help desk support element where schools can phone in or email in asking for advice and guidance on a complaint they've received or how to progress it through the process. We're often asked for advice around outcomes and remedies because, just as with complaints themselves, we often see requests that are reasonable and therefore they're in scope for delivery, but we also have instances where requests are unreasonable and they're not deliverable through the complaints process. So in terms of requests that are reasonable, so where somebody requests an apology and that apology is deemed to be appropriate or necessary, that absolutely is reasonable and is within the scope of the complaints policy to deliver it, as is acknowledging that something could have been handled in a better way, which will go a long way to making the person feel that it was worth their taking their time in raising the complaint. And with most reasonable people, they should accept that the school has acknowledged that. Explaining what will be done to prevent this matter from happening again. Lots of the complaints that I'm asked to read and give a view on often state within them that I appreciate that you can't change this for for me or my child. However, the main reason I'm making this complaint is to try and prevent another family from going through this. We can also demonstrate that you have used the complaints process as a feedback tool for positive action, and so it was worthwhile in making that complaint. So it actually demonstrates that the process works. What's unreasonable, and these are requests that we see made frequently, people requesting that a member of staff be disciplined or dismissed as a direct result of a complaint. Even if the complaint is upheld against a member of staff, a confidential HR process would then ensue, and the complainant would not be privy to any additional information by having made a complaint than they would be had they not made that complaint. So it makes no difference to whether they've made a complaint or not, because the employer and the employee would then engage in a confidential process. Suspending or permanently excluding another pupil at the complainant's request is also an unreasonable request, and one that isn't in scope. Only the head teacher can make the decision ultimately to exclude, and the complaints procedure cannot be used to try and exert pressure on the head to do so. Dismissing a member of staff as a direct result of complaint as well. Same with disciplinary measures. They can't invoke the complaints procedure to say that, for example, the only outcome I will accept is if you dismiss this member of staff. And then last but not least, deviating from what you would do usually because somebody keeps coming back. If you were to do that, this is likely to make the person come back again for more, either on this occasion or on future ones, on the basis that they will get the impression wrongly that essentially if they persist loudly enough and for long enough, eventually you will change your position. And your position may be entirely based on fact and entirely reasonable, so you do not need to deviate from that. In terms of making recommendations, it's really important when making those recommendations that you think about their appropriateness, whether they're proportionate in the circumstances, that they're measurable, and that they're achievable. When you notify the complainant about any recommendations that are going to be implemented, always be clear on the timescale for this, as this should help to avoid a situation where a complainant chases you up or seeks to make a further complaint sometime later about a perceived lack of action. Not all recommendations can take place and be implemented quickly. Sometimes, for example, a recommendation arising from a complaints process may involve an update or a revision to a school policy or procedure that needs to be agreed by the governing board. So always be clear with somebody if it's going to take perhaps 5 or 6 weeks, give them that time frame and confirm to them that you'll write to them once the recommendation has been fully implemented, so that the person doesn't just perceive that nothing's happening. I'll have to raise a further complaint to try to galvanize the school into some action. The school's probably working very hard behind the scenes to implement the recommendation. The person just cannot see the benefits of it yet. Always remember as well that you do not need to notify the complainant of any recommendations that were proposed and considered but were not ultimately agreed for implementation. You only have to write to them in the final outcome letter to state which recommendations have actually been implemented, state whose responsibility it is for overseeing that recommendation, and as I say, a timescale attached to it. So we'll also look today, as we get lots of requests around what's the position for staff being complained about. So we'll look at that, and we'll also look at what's the position where staff members are not necessarily being complained about, but they're also cited potentially as a witness. And what does that process involve? So where a member of staff is being complained about, always remember that complaints very much are a scenario where the initial complaint is one side of a story, and it's important that we seek to establish the other side. So to that end, members of staff who are the subject of a complaint will have the right to reply. They'll get to have their say on the allegations that have been made, and in line with the principles of fairness and natural justice. So current employees must cooperate with the formal complaints process, and they can be required to do so if necessary by the governing board, for example. Former employees, it's slightly more tricky. They can be contacted and they can be asked to cooperate with the formal complaints process, but they cannot be compelled to participate in the same way that a current employee can. It's always important to be clear what issues regarding a member of staff fall under the formal complaints process and what issues fall under a separate statutory process, such as a grievance or disciplinary process. The complaints process itself cannot be used, as we've already looked at, to complain about something that has been or can still be considered by way of a separate statutory process, such as those ones above, like grievances or disciplinary processes, or if something is either about to go to a tribunal or has the potential to go to one. Ultimately, where a separate statutory process applies, that separate process takes precedence. You cannot have two processes considering the same matter, because within that, you run a risk of arriving at a variance in findings and outcomes. You then have the question mark of, well, which process takes precedence? Obviously, the complainant will always want the process that led to the most favourable outcome to be the one that's taken forward, but that may well not be the case in reality in terms of which one does apply and take precedence. So this is why we always should only consider something once. Do it well, do it once. We also need to remember that members of staff who are the subject of a complaint may also be accompanied during the complaints process if they wish. So, for example, they can be accompanied by a colleague or a union representative. Now, this can be at any stage of the complaints process, such as an interview during a complaint investigation at the first formal stage, or it could be where they attend the hearing of a complaint as a witness. In terms of staff being called as a witness, there are occasions when they're not the focus of the complaint itself, but potentially the complainant, so a parent, a carer, or special guardian, might name the member of staff potentially as a witness, or the respondent on behalf of the school during the course of their investigation may identify a member of staff as a potential witness. We tend to see complaint cases involving witnesses usually in the case of a disputed event or incident where we're seeking to establish what did or didn't happen. So witnesses can be asked to provide a witness statement or to attend the hearing itself, or on some occasions they can be asked to do both. The reason for having witness statements is because it usually helps to cut down on having an unwieldy number of witnesses attend a hearing. Now, it's not unusual for a member of staff, in my experience, to attend a complaint hearing in addition to submitting the statement itself. And this is because the panel may well have questions for the person, either that the witness statement doesn't answer, or because the statement provided actually has led the panel to having further questions in addition to the original ones. It's not always the case, for example, that the panel has questions just for the complainant and the respondent on behalf of the school. The panel, in theory, could have questions for anybody in attendance. It's also important to remember that staff members can be accompanied where they're a witness during all formal stages of the process, as is their right to be supported. And as before on the previous slide, current employees must also cooperate if they're called as a witness, and they can be required to do so by the governing board if necessary. Former employees, again, can be contacted and asked to cooperate. So, for example, if somebody has since, say, retired, they can be notified that a complaint has been received where they have either been named as a witness, or the school has identified that they may have potentially helpful information that could shed some light on this complaint. They can be asked to submit a witness statement, for example, but they cannot be compelled to participate in the same way that they would have been had they still been a current employee. Does anybody else have any questions up to this point, or would like me to recap on anything?
Yeah, we've had one question so far, and it's a really good one, and it's quite a common question. They said that their biggest concern is a serial complainer. They complain about everything. It always gets to stage 3, and we always accept and apologise, and it's all about little things that happen, like a child asked to remove a festival bracelet, and it just continuous.
Okay.
Have you any advice on that?
Yes, I do. It's always important to think about having guidance in place. So you have to have your, it's a requirement that you have to have a complaints process that sets out the stages and all those requirements that we've been through. But it's also strongly recommended that you need to have guidance on dealing with unreasonable behaviour. Now that can be both in relation to complaints, but also more widely. So for a number of years in Hertfordshire now, for example, with the Hertfordshire schools that we work with, we have recommended that in their guidance on dealing with complaints that are often, people will probably be familiar with the term vexatious, is a term that comes up frequently. The importance to remember here is it's the complaint that we must determine is vexatious or not the person. So even though somebody, the way they present can often come across as extremely unreasonable, often adversarial from the start, to the extent that they tell us, essentially, I'm having to go through your complaints process. I'm going through the motions because I won't let you sweep this under the carpet. I won't accept what you tell me, but I need to complete your process before I can go to the Department for Education, or I go to my MP, or I go to Ofsted. So what we always are very clear on, and we recommend through our support, is that never be seen to brand somebody vexatious, even if that very much is how it appears to you. It's each situation that they seek to present to you. But within that, it's important to be clear that you can have guidance in place, not just to protect staff and governors from unreasonable and vexatious complaints, but also unreasonable behaviour more generally. So for a number of years in Hertfordshire now, we have recommended that schools include some wording, some brief wording to the effect that the school reserves the right to use this policy to deal with unreasonable behaviour and vexatious complaints, not necessarily only arising from complaint scenarios. So if somebody's behaviour is difficult, it's time consuming, it's stressful for staff and governors, it's impacting on people's health and well-being, and ultimately if it's impacting the school or the trust's ability to function as it otherwise normally would have done, you absolutely are able to take action to try to prevent that from going on any longer than it has already. That way you can take steps in the form of perhaps imposing some kind of communication management measures, to say that there'll be no more face-to-face meetings until further notice, saying that further communications must be in writing, perhaps to a designated member of staff or mailbox. And you could gradually ramp up those management measures depending on the severity and the level of the situation that you're faced with. Some schools in extreme situations over the years where I've been asked to support, I have known schools that have introduced what they call an aggregated reply method, where it's reached a point where certain complainants have, to all intents and purposes, been hounding a particular member of staff or a particular school, and it's clear that actually they're not going to stop, so we need to take action to try and stop them. We've introduced something called an aggregated reply method, where it's made clear to that person that no matter how many times going forward you contact us in a given week or fortnight, we will respond once a fortnight or once a week by close of school on the following Tuesday, irrespective of how many attempts at contact that you make, being clear that only if we deem it's necessary, we will only respond going forward to new issues. Because actually, if they've raised it over and over again, either through the complaints process or outside the provisions of the process, because not everybody follows the complaints process as they should. We also need to acknowledge that. But where we've been very clear with somebody what our position is, we've either dealt with it as a complaint or we've signposted them to the procedure, but they've never engaged. We are able to demonstrate that we're going to draw a line under that, because actually, yes, we have a duty of care to your child, but also we have a duty of care to our staff here, and our staff do not come to work to basically put themselves in a position of being abused by you. And we also have to bear in mind within that governors and trustees are giving up their time, and they're not giving up their time willingly to have to come into school and also to deal with abuse. So it works both ways in terms of, yes, we have a duty of care to pupils, but we also have a duty of care to staff and governors. So I would strongly recommend having guidance in place, if you haven't already, that deals with unreasonable behaviour and vexatious complaints, but also that contains that short paragraph that makes it clear that there will be occasions where we reserve the right to invoke this policy and procedure and adapt it, even in situations where a complaint hasn't been made, because it affords you the option of taking steps to protect your staff and governors, and also to protect the school environment. So if somebody's behaviour is so challenging that they're coming into school behaving inappropriately, it's distressing for staff, governors, other parents, other pupils. They absolutely shouldn't be doing that. You ultimately can take action to restrict the person's access to the premises, which is not something that schools ever sort of jump to and want to do readily. But schools are ultimately private property, and you are able to regulate who can come onto the premises because they have an implied license to access rather than an automatic right to come on the premises. So we recommend communication management measures first, having already warned the person, give the person fair warning, give them a chance to sort of improve their behaviour. And it's always better if somebody works with us than against us. We don't want the conflict, and we would hope that they don't really either. But work on a scale of increasing the actions that you take up to the point that's necessary, to show that you've actually, in the face of quite considerable adversity, we've acted very reasonably with you. We've given you chances. We've asked you to refrain from doing this. We've given you examples of your inappropriate behaviour, and regrettably, you still haven't acted upon our requests. You now leave us with no alternative but to take the following steps. It's all about demonstrating. It's a question of cause and effect. So I hope that helps.
Absolutely. If I had this advice when I was a head teacher, I'd been really appreciative of it, because actually sometimes when you're a new head teacher, you don't have all the information you need to in some way protect yourself from the complaints and how you do things. Because if you follow the structure that you mentioned, which everyone uses, actually it becomes less hassle for you. So yeah, and the person who raised the question said thank you, it was really useful.
Oh, great. One last thing on this, I would always remind you, is it's often it's tempting to think that you start doubting yourself. Have I done something wrong here? And you can often feel worried and anxious about it, but you can also feel a little bit ashamed. Well, actually, how have we got ourselves into this position with this person? Am I the only one? Are we the only school? Chances are absolutely not. There are other people out there that are facing a very similar situation through no fault of their own. You've unfortunately come up against somebody who isn't acting rationally, and they've got wholly unreasonable expectations of what they're setting out to achieve and how they're going about it. Never think it's only you and that you're on your own. There's always sources of help and advice out there, and it very much is the case that by, for example, ringing us up or sending us an email, we'll reply to you, and we can draw on experience of dealing with cases like this from years gone by, as well as current ones we may be involved in supporting. We can help you realize actually it isn't just you. This is a growing problem, and so it's not down to any particular failure of your school or any individuals at your school. It's just an unfortunate sort of combination of factors where this person is angry or upset. They have decided that you are to blame, rightly or wrongly, and that they're not going to rest until they feel that they've had their day in court, which is even sort of the terminology that some of these people use. It's really distressing, it's time consuming, but you're absolutely not on your own, and you're not the only ones.
And actually, that's why we set up the Head Teacher Chat community, is actually to support people and not feel on your own. We get quite a few messages about parent complaints in the community and on all our groups, and actually it is a common thing. And yeah, so I'm going to hand over for the last section of this webinar. It's been brilliant so far. As I said, it's been so much information, so many strategies, and actually clearing up a lot of information. So thank you so far.
All right, you're welcome. Thanks very much. So in terms of what staff can expect at a hearing, whether they are the focus of the complaint that's been made, and therefore they're having to attend as a respondent, or whether they're attending as a witness, we just thought it's helpful to go through what you can expect to see, bearing in mind that there's always a time when a particular complaints process is that staff member's first ever formal complaints process. So this is a suggested formal hearing layout that we suggest to schools that subscribe to our complaints toolkit. So you have panel members on one table at the head of the room. You have the complainant and their supporter, friend or representative on another, the head teacher and their supporter, friend or representative on a separate table. And then finally, you have the clerk, now known as the GPC, Governance Professional Clerk, seated on a fourth table with space for being accompanied by any witnesses who are ushered in and out. The clerk should be seated next to the entry or exit of the room in order to facilitate bringing the witnesses in and out, because witnesses only attend for the part of the hearing where they're required to repeat their statement if necessary, or to answer any questions that the panel has. The advantage of having this kind of layout as well is that everybody can see one another. So for example, if any of the attendees may have a hearing impairment, then this environment is helpful because it allows everybody to see and lip read the other parties. We also make it clear that any other requests for reasonable adjustment will be considered in line with this. But this environment tends to work best in terms of openness and transparency by allowing everyone to see each other. We've also, within the toolkit, we provide details on a suggested agenda for a formal complaints hearing that's here. So a copy of this should be included in the panel packs that everybody receives in advance of the hearing, but we also suggest that you place additional copies of this suggested hearing format on the desks in the room where the hearing is going to take place. It's really important that between them, the clerk and the chair, particularly the chair of the panel, that they try and stick to this agenda to ensure that everything gets covered that should be covered, but also to ensure that the hearing runs to a reasonable time frame. In terms of some good housekeeping at the beginning of the hearing, it's really important that the chair welcomes everybody and tries to put them at ease. The guidance on this states that the hearing should be kept as informal as possible, but we also have to balance this with the knowledge that it's actually a formal hearing of a complaint. So it's about how we strike that balance. So to do that, we try to put people as much at ease by welcoming them, thinking on occasions, of course, that this could well be the person's first ever time of being in any kind of formal complaint hearing as the complainant. And there will be occasions when it's a new head teacher's first ever complaints hearing. It can be really daunting. We hear lots and lots about how complainants find complaints processes can be stressful and the time and trouble that they've gone to in making a complaint. But what often gets overlooked and spoken about very little is that complaints processes are just as stressful, if not more so, for those on the receiving end of the complaint. So those who have had allegations made against them, or those caught in the middle. So those dealing with the complaint, it can be stressful on occasions for the panel members as well, because they can see both sides of the story here. They can see that the complainant is very angry and upset about what's happened, and raises some good points. However, at the same time, they can see from the school submission that actually the school had a very difficult decision to make in time-limited circumstances, and actually the school, according to its policy and procedure, the school acted correctly. So whilst the decision may have been an unwelcome one for the parent and for their child, the decision wasn't wrong. And they can often be very challenging situations to hear and then to send an outcome letter in relation to. It's also important past the initial welcomes to point out where the fire exits are, and if there's going to be any fire alarm drill going off, for example, point out where the toilets are and be clear that you're willing to agree to any requests for toilet comfort breaks. Be clear on the use of mobiles. Most of the schools that we work with and support, the use of mobiles in a complaints hearing, it's made clear, is prohibited. Be clear on refreshments. So if refreshments are available, as a minimum, we suggest that water and some tissues be on hand, particularly if the complainant is likely to get upset about the issues they've raised within the complaint and having to go over them. And something the chair should do with the assistance of the clerk if necessary, by prompting introductions, by asking the parties to state the names and the capacity that they are there attending the hearing in. This is in the interests of openness and transparency, and bearing in mind that you do not have to allow entry to anybody whose attendance has not been confirmed in advance of the hearing. So, for example, it helps to avoid any unpleasant surprises. So, for example, a complainant turning up at the last minute with a legal representative when they previously hadn't indicated that they would be doing so. The guidance on this, legal representatives are not prohibited from attending a school complaints hearing. However, the DfE guidance on this does make it clear it actively discourages complainants from bringing along legal representatives on the basis that it's a school complaints hearing. Ultimately, it is not a hearing in a court of law. And on that basis, it's unlikely that having a legal representative there is going to give the parent sort of any advantage that they wouldn't otherwise have had. It's also important as well to highlight in the opening housekeeping that the clerk is there to take notes and to ensure procedural compliance by the panel. The clerk is not a decision maker. So the complainants and respondents are not usually invited to question one another, as all of the questioning tends to be conducted by the panel. But we are aware that of some schools that we work with where their particular policy that they've adopted does state that cross-questioning is allowed. If your policy does permit cross-questioning, that's fine, but what we would recommend is that the chair of your complaints panel needs to be prepared to intervene if necessary, because on some occasions, allowing cross-questioning can lead to the hearing being more confrontational than it would have been had the questioning only been conducted by the panel. It can also lead to hearings taking much longer. So we recommend that the chair clarifies how questioning will be conducted and allow both parties the same amount of time to question one another if cross-questioning is permitted. In terms of the panel asking its questions, everybody should be made aware that the panel may ask questions at any point in order to clarify information. And on occasions, the meeting can be adjourned if necessary in order to clarify a piece of information on a statement somebody may have made. Witnesses are only required to attend the part of the hearing in which they're required to give their evidence or to answer any questions that the panel may have. They do not stay for the duration of the hearing. And as I've said, the panel only will admit people who have been formally invited to the hearing and whose attendance has been confirmed in writing in advance. Both the parties, so the complainant and the respondent on behalf of the school, are entitled to be accompanied by a friend, supporter or representative, but that's one person per party. They cannot come with a team of people. It helps to keep the hearing to a reasonable length and avoids sort of one party feeling intimidated by the number of supporters and representatives on the other. The clerk's notes are the official record of the meeting, and the DFE expects now that the clerk's notes should be sent to both parties after the hearing. It used to be the case that there wasn't this expectation and the parties could request them after the event, but the DFE now expects that those notes should be routinely shared. Also, the chair and clerk can make it clear that the attendees are welcome to take their own notes in addition to the clerk taking notes if they wish to. And once the hearing has concluded and the clerk escorts the parties out, the clerk then returns to the panel and remains behind in order to provide any further advice or guidance that the panel members require whilst they deliberate. Now, the deliberation stage should take place ideally on the same afternoon or evening of the panel itself, whilst the events that have been covered are fresh in the memory. It ultimately depends on how late in the day that the panel actually finishes. If the panel does need to adjourn, they'll then have to reconvene at a later date to conclude their deliberation stage, which is often not convenient for the panel members. It can be difficult enough getting 3 people together with a clerk with that mutual availability to actually hear the complaint on one date without having to clear some time to then convene again to have your deliberations on another. So in terms of lines of inquiry and questioning, all of the parties will receive a panel pack in advance of the hearing. So the 3 panel members, the clerk, the respondent on behalf of the school, and the complainant. Everybody should read it because the preparation for this is absolutely key. Not reading the panel pack can lead on occasions to unnecessary questions being asked that the information in the pack already answers. The panel members should meet in advance of the hearing date to agree the questions that they are going to ask and who's going to ask which one. If your policy, your complaints policy does not permit cross-questioning, then both the complainant and the respondent need to think carefully about their case and any questions that they do have once they've read the pack, because they'll get the opportunity to make the panel aware of these questions and concerns during the hearing. The panel can then decide whether to ask those questions or whether they consider as a panel that those matters have already been sufficiently covered, both through the oral submissions that they've heard that day, as well as in the written submissions contained in the panel pack. If the complaints policy does permit cross-questioning, then the parties will be permitted to ask their own questions at the appropriate point as directed by the clerk and the chair. We also point out that if any aspects of the complaint are unclear to panel members once they receive the evidence pack, the panel has the opportunity to invite either party to clarify particular points. This can be done either by way of written representations in advance or what we call clarification meetings in advance of the hearing. It's not a means by which to head off having the panel. The panel still needs to take place with the parties present. However, it's an opportunity for the panel to gain clarification so that the panel is best placed on the day or the evening itself to reach a definitive outcome. We really do want to reach definitive outcomes because this is what the complainant wants. It's in their best interest, but it's also in the best interest for us as a school as well. We don't want complaints seemingly remaining open indefinitely. We want to reach a point in time where we feel like we've dealt with this, we're now drawing a line under it and bringing a full stop to it. So that concludes the actual school's local internal complaints process, but what can happen beyond the school's complaints process? So there are a number of potential routes where the complaint could go. So we'll just touch on some of them briefly today as we begin to close. So the parent could, or complainant, whoever they may be, could potentially approach the local authority, particularly if the school is still a maintained school. I worked for a local authority for a number of years, and we used to see quite a lot of this, where complainants would approach the local authority on the basis that they still believed that councils controlled schools as they used to many years ago, wanting the council to intervene to tell a school that they could or could not do a particular thing. The LA responded consistently to be clear that they would not become involved in school-based complaints. And so they tended to reply that they didn't control schools. They had not done so for decades. They directed the person, therefore, back to the school's complaints process, because it would often be the case that the person would be approaching the local authority either without having completed the school's complaints process or without even having started it in the first place, essentially wanting to come straight to the local authority and circumvent the school. Another approach taken by a number of complainants is to go to Ofsted. Either this could be before complaining to the school, either during the complaints process with the school, or afterwards. Ofsted makes it clear that it does not investigate school-based complaints, but that it may retain the details for a future inspection. And so the actual wording on the gov.uk website states that if you complain about a school to Ofsted, this does not mean that we will carry out an inspection because of your complaint. They go on to state that our inspectors may discuss the issues raised in your complaint with the school when they carry out their usual inspection. So it won't make Ofsted potentially bring forward an inspection or anything like that, but it doesn't stop some complainants thinking it or wishing that were true. Ultimately, once the school's process has been completed, then the parent, carer, special guardian, whoever the complainant is, can approach the Department for Education, and the complaint would be potentially considered by their SCCU, their School Complaints Compliance Unit. Now, the DFE is very clear within its guidance that it will only give further consideration to complaints in the following scenarios, and those scenarios are here. So if the setting in question does not have a complaints procedure, if that setting did not provide a copy of its complaints procedure when requested, if it does not have a procedure that complies with the statutory regulations, if it has not followed its published procedure, or it has not allowed its complaints procedure to be completed. So, for example, not agreeing or allowing somebody to escalate their complaint. They also make it clear that they will not change an academy or a maintained school's decision about a complaint simply because the complainant disagrees with it. Their role is to make sure that the academy or maintained school handles complaints properly by following a complaint through its published process. They will not substitute their decision for that of the panel that considered it simply because the complainant is unhappy and thinks that the decision is unfair. There has to have been fault in terms of how the outcome was reached, or at least potential fault, for the DFE to then decide that actually we're going to undertake further inquiries, or on some occasions a further investigation into this. So provided, bearing that in mind, that the school, the federation or the trust in question has complied with those 5 points, it's highly unlikely that the DFE will actually undertake further inquiries at all, bearing in mind, of course, that they as a department receive far more approaches each year than they actually investigate, and that they actually even undertake preliminary inquiries into. So in terms of some key links, as we begin to close, there's some key links both for academies and maintained schools. So the first 3 links are for academies and free schools. So the complaints requirements for academies and free schools are set out in the link at the top. The Education Independent School Standards Regulations 2014, and it's part 7 that refers to complaints here. Best practice guidance for academies and their complaints procedures. There's a guidance document that was originally created by the Education and Skills Funding Agency, but obviously this closed at the end of March, and all of their functions have, for the time being at least, moved in-house into the Department for Education. And there remains a model complaints procedure for academies that is still available as well. And then the Education Act 2002, it's Part 3, Chapter 1, Section 29, that sets out the exact requirements for a maintained school in terms of what it must do in relation to complaints. There's also a model complaints procedure for maintained schools. And at the bottom here, there is a model policy for managing serial and unreasonable complaints that either a maintained school or an academy or free school is welcome to look at, use and adopt. Because it's really important, as we've already touched upon in the session, thanks to that question earlier, it's important that you have such guidance in place for setting out, firstly, how does the school determine if something is serial and unreasonable, and then secondly, moving on from that, once it's determined that it's serial and unreasonable, what is the school or the trust's position in terms of how we're going to approach dealing with that. So just moving on to some useful reminders. So always bear in mind that your school policies and procedures are there for genuine reasons. Irrespective of what a parent thinks about them, your policies and procedures are there to help you fulfill your legal obligations and to enable you at the end of the day to make clear and fair decisions that apply to all. What somebody wants and what they're actually entitled to, according to a policy, or in other cases, education legislation, for example, what they want and what they actually get through entitlement are often 2 very different things. And sometimes, in some instances, there is no entitlement at all in terms of what they're asking for, or in some cases demanding. If someone appears to be acting unreasonably and states that in their view they perceive they're being discriminated against or victimized, or their child is, because their request for something has been refused, even if it was for legitimate reasons, always seek to address allegations like this directly. Even if you were not initially minded to comment on allegations of this nature for fear perhaps of being seen to make them worse, make sure that you do. Not commenting on allegations like this usually results in the complainant feeling that the issue's been ignored, and it then makes them more likely to pursue the matter even further. It's also important to bear in mind that the complaints process is supposed to be a positive mechanism for change and identifying improvements. So looking at where apologies or improvements may be necessary rather than a negative one. It has not been designed to be a deliberately negative process. So it's not for apportioning blame to any particular individual. It's not for humiliating people or for hounding them out of their jobs. It's about identifying where we could have perhaps handled something differently or better, and apologising for that and stating what we intend to do to prevent this matter from occurring again. Also think about that if you exercise the discretion to make an exception on some occasions, be clear about why you did this. think about, for example, how you would explain this. If further inquiry ended up coming in from the Department for Education, from the School Complaints Compliance Unit, it sometimes can. If they ask you to explain, well, why did you do this on this occasion, but perhaps not on another, be clear about the reasons that you did that. Because what you're prepared to do for one person, you need to be prepared to potentially do it for another. So it's important to be careful not to be seen to set a precedent. If you are doing something as a gesture of goodwill, for example, to try and resolve a matter amicably, be clear that you've exercised the discretion to do this on this occasion. So you're making it clear that we're not fundamentally changing or ignoring a procedure that we have in place. We are doing this on this occasion for the following reasons. Always bear in mind that sometimes the more you aim to accommodate somebody, they keep asking you for further adaptations and for more exceptions to be granted, rather than simply being grateful for those that already have. So you can, through no fault of your own, often end up feeling that you're in a position where your kind and compassionate nature is being taken advantage of by somebody. Always be clear about what you can and cannot do and why. Sometimes people wrongly interpret it that, so you're saying no because you perceive that I'm a difficult person. Actually, it's not that at all. To an extent, my hands are tied here, because this, in relation to what you're asking, this is what the law says. The school's policy on this therefore complies with the law. So I'm unable to agree to what you're asking, rather than just being simply unwilling to give it to you. It's also important to be clear in situations where there's nothing further to add to what's already been said. Be clear about that, because ultimately, if somebody keeps coming back to you and it's adding nothing, it's still taking time. It's stressful and time consuming, and actually it's serving no further purpose. So there is now guidance. There's brief guidance on this from the Department for Education. There's a section called "When to Stop Responding," and that's on the gov.uk website. If you haven't seen it, I'd strongly recommend that you have a look at it, because it can help you draw a line under such matters. As I said earlier in the session, in answer to one of the questions, please don't feel that you need to struggle on alone. Complaints can feel incredibly isolating, depending on what they're about, or how the person has framed the complaint, or that person's presenting behaviours. There's always help and support out there. It's only ever an email or a phone call away. You can talk to us, for example, and we can draw on experience of previous cases to help you realise that actually it's not only you're not the only ones, and that actually there are ways out of this. There's ways around these situations. The DfE expects all escalation requests to be accepted, in order that the complainant can complete the full published complaints process. They say that they will not accept and consider a complaint further unless they're satisfied that the complainant has either exhausted the school's complaints procedure, or at least attempted to do so. So it's really important to bear that in mind, that escalation requests have to be agreed to as per the DfE expectation. And then if they do come calling in terms of making further inquiries, that's one big box to tick in terms of the school being able to demonstrate, yes, they were afforded full access to our complaints policy, and here are the outcome letters, so that we'll share them with you so you can see how the decisions were arrived at. So in terms of just last but not least, looking at some frequently asked questions. So something we get asked a lot is, what if the complainant tries to introduce legal arguments, particularly during the panel stage? This can come up. It's always important to remember that the complaints process is not a court of law, or any kind of litigation process. So the DfE guidance, as I've already mentioned, actively discourages complainants from being accompanied by a solicitor or a legal representative. And so if that person attempts to bring legal arguments into the equation, the other consideration to have is that the panel members are there to serve as impartial panel members and school governors. So unless their own professional background is in legal services, they are not there. They're not required to have a legal background. And so it would simply be a coincidence if they worked in legal services that they did have any kind of legal background, but they're there serving as an impartial panel member. So having a legal representative with the parent is unlikely to help the parent gain any kind of advantage that they would not have had that person not been there. The second question we get asked a lot about is if ultimately, what if we're unable to reach an agreement or any kind of compromise with the complainant? On this, it's important ultimately to be realistic. We cannot always agree with somebody. There are occasions when the person simply doesn't wish to compromise, or just as we appear to be nearing the end of the process, we thought we were inching towards agreement, the person then may seek to move the goalposts, and so on. It can happen again and again. So it's important where we decide to draw the line and be clear about our final position and the reasons why. And we also get asked, where can we seek help and support? So we offer a range of complaints services, including our complaints toolkit, which will be on the final slide. I've got some screenshots for you. This is available through an annual subscription. We also offer complaint reviews, complaint plans. We offer independent investigations, panel preparation sessions, complaint policy reviews, policy summaries and flowcharts, and we also offer bespoke training and webinars on topics that you ask us to deliver on. The complaints toolkit contains a number of self-service resources, so there's some screenshots of it there. The key ones are it has a step-by-step guide in terms of who should do what and in what time scale, and also it sets out if the complaint is a little bit more unusual and doesn't seem to follow the standard formula, what should we do instead? It contains a set of suggested acknowledgement and response letters for each key step of the process, so you know what to say and to whom at the appropriate time. It's got a summary of the whole process in flowchart format that you could use, for example, on your website or send out to parents when you acknowledge or respond to their complaints. And it has a list of essential do's and don'ts to help promote best practice and also to avoid some of the pitfalls that there can be when dealing with a complaint. It also contains access to a termly webinar on a complaints related topic. These webinars take place live with the opportunity for questions and answers, a bit like this one, but we also record them so that anybody who cannot attend or who buys the toolkit after that webinar has taken place, they can still access the slides and the content recording. There's also the option of submitting feedback on the toolkit throughout the year as you use it. We're always keen to hear what you found most useful, but also what other resources you would like to see, because each year we do an annual review and we look to update it based on the feedback from subscribing schools. And last but not least, it contains a help desk support element. So you're able to email our help desk or phone through, and you can have advice from me, either general complaints advice or specific case advice, where we can help you in terms of identifying what you need to do next and who needs to do it. So that concludes the session today. So I hope that that's been a useful one for you, and that you feel more confident than you did at the start about dealing with complaints, and particularly to do with this rise we're seeing in unreasonable behaviour. It's definitely a nationwide problem rather than a localised one.
Oh, thank you very much, Paul. That was absolutely brilliant. The information that you shared and all the strategies and things like that was superb. And I think the key bit is, and what we find a lot when we're talking to head teachers is about that you're not alone. And actually there is a support network that can help you and you can get advice from. And so where do people find more information about what you do? Is it basically go to?
So there's one more on the last slide. There's sort of a final end slide with the details of our website.
Okay.
So you can go on, if you go onto the HFL website, and we also have the HFL hub. So any products and services that you buy from us, you can access through the HFL hub, and there's a hub shop which sets out everything that we offer, and then you can look through there, see what's relevant to you depending on the challenges that you're facing, or you can use those details there. You can send us an email. We have a dedicated email address for school-based complaints inquiries, as well as the help desk support. So we're always happy to respond either by email, or some schools prefer a phone call, a bit more personal, but we'll always discuss what your requirements are and the situation that you're facing, and we'll only ever recommend what's sort of the best value product for you. For example, we wouldn't recommend, oh, this sounds tricky, you need an independent investigation taking X number of hours. We're guided by you in terms of what you're asking us to do. If we'll always advise you on the most cost-effective way. So if we think you can resolve something in-house, we'll give you advice on how to resolve it in-house effectively, cost-free, where we can.
That's really good to know. And yeah, thank you very much for your time today, Paul. It's been greatly appreciated, and I'm sure it's going to help a lot of head teachers and school leaders out there. So thank you for joining us on our Head Teacher Chat Masterclass today on dealing with complaints and the challenges they present. And we look forward to seeing you on the next one. So thank you, everyone.
Thanks for having me. Thank you.
You're welcome.